Hello, welcome to another of Napthan's Brief Conversations. My name's Kathryn Harwood. I'm a partner in our private client team, and I'm joined this morning by my colleague Nicola Turner from our litigation team. Nicola and I are just going to have a quick chat today about the consequences where somebody dies without having made a will. Astonishingly, or to me at least, almost 3/4 of the population of the UK die every year without having made a will. I think probably the biggest reason for that is because people genuinely don't understand what the consequences of that may be. I think, Nicola, one of the biggest areas we come across is actually unmarried couples, isn't it?
Absolutely. Most people still seem to be of the view that if they've been cohabiting for a long time, that they are given the same treatment under the law as if they were married. People often still quote to me the phrase common law husband, common law wife, which obviously doesn't exist. Unfortunately, if their partner dies, they find themselves in a really difficult situation, which obviously at the same time of having to deal with the tragedy of the loss of their partner can be just an awful situation to find themselves in. If their partner dies, they're left with nothing under the rules of intestacy. And then obviously that's where we might come in and try to assist them in making a claim against the estate. There is legislation in place that enables that to happen so that we can try to readdress the balance for the cohabitee. But unfortunately, even then, the law is not as generous to cohabitees and surviving partners as it is to spouses. And what we are able to do for them is more limited. So yeah, unfortunately, it can be a really difficult situation for people to find themselves in, particularly if there's children involved, because they will then find themselves potentially having to make a claim against their own children.
Absolutely, suing their own children.
Suing their own children, absolutely, or children from a previous marriage, which can get extremely complicated and emotional. So it's a difficult area.
Yeah. And I think, in an intestacy like that, where the estate would then naturally be going to the children, I think the court is very protective of those children's rights, isn't it, in terms of spousal claim?
Absolutely. I mean, any case involving children has to have the involvement of the court, and that's obviously for their protection, to make sure that anything that's done is in their best interests and protects them. So it means that the process is a formal one and a more complicated one. And as you say, that the court is very careful to make sure the children are protected. And that can lead to some inflexibility sometimes in the arrangements that we can try to put in place, particularly when it comes to things like the home, the family home, and how the partner's rights there can be protected. I mean, obviously, there are things that we can do, but for the sake of a quick trip to the solicitor's office to make a will, all that can be avoided. I mean, in addition to looking at their will and what they might want to do there, people should also perhaps look at their property setup, and if that reflects the true position and how they want that to be dealt with forward, once they've formed a new relationship.
Yeah, absolutely. There just isn't that overriding jurisdiction for unmarried couples that we have for married people, is there? Which I think is a problem. But I mean, I think even for married couples, Nicola, there are assumptions which aren't necessarily going to follow through, aren't there?
That's right. I mean, again, in an intestacy, if somebody dies without a will, it's much more generous for spouses, particularly where it's a relatively small or modest estate or medium-sized estate, that the spouse will probably come out with enough to be sufficient. They'll get a large capital sum, 270,000, and half of whatever there is left. But where you're dealing with the larger estates, again, it's a problem, because there can be a whole other realm of assets and capital and investments that don't pass to the spouse, and will pass again to the children. And again, you can find yourself having to bring a claim for that spouse. And again, the legislation that enables the claim to be brought is more generous for spouses, and certainly there's much more that we can do. But again, it means litigation and involving somebody like me for a long period of time.
Absolutely. I mean, I have on a number of occasions over the years sat with clients whilst they have pondered and gone through their assets and tried to work out whether the intestacy provisions will be sufficient to get them where they need to be, you know, and you think, well, why worry about all of that when actually you can just sit down with, just make a will, which is what you wanted to say, you know. It's astonishing, really. But I think the other thing there, you know, people maybe realise that they should make a will, but not all wills are equal, are they? You know.
No, that's right. I mean, even when people take that step, they have to really think about what it is they're trying to achieve. I mean, I can remember being consulted by one of our non-contentious lawyers who was looking to draft a will for a very wealthy person who had remarried and had adult children. And he was considering making a will that gave his new spouse very, very small percentage of his estate, probably about 2%, and leaving the rest to his children. But at the same time was going to make his new wife the executor of the estate. And you know, that was logical to them. But of course, from my perspective, looking at what's going to happen after they've sadly died, you know, the first thing is, well, you've got a lot of money there to divide between your spouse and your children. 2% is at a level where, you know, as soon as any legal advice is given, that's going to result in a claim being made for further provision from the estate under the Inheritance Act. But also giving the probably unhappy spouse control of the estate in the form of the executorship really isn't something that we would ever advise. So obviously, you know, they took the good step of coming to see us and getting that advice, and we tweaked things and made sure that, you know, we took steps to try to prevent what, in my view, would have been an inevitable claim, even on the basis of there being a will in place.
Yeah, I mean, I think, Nicola, I mean, the important thing is, I mean, in this country, we're not like France, we're not like other European countries where we have forced heirship rules. So we do have full testamentary freedom. But I think it's very important that when clients make the wills they want to make, they do so in a fully informed way, so that if there is the potential for a claim being made after their death, we can forewarn them and we can maybe tweak and just take some protective steps there that'll make it work. But
yes, you never guarantee that a claim won't be made. And obviously there are cases where it's right that a claim is made, or certainly the claimant will think so. But definitely there are cases where, with our involvement, you know, obviously the hope is that we make that will a little bit more robust.
I think that's the key word, isn't it, Nicola? In terms of having a will, you want to make sure that its terms will come into play following your death. So making it robust, that's absolutely essential, isn't it? And I think, you know, that comes very much to how you go about making your will, and maybe if you're thinking about having a go at it yourself.
Yeah, absolutely. I mean, it's particularly at the moment, it's a really hot topic, obviously, with recent events in the world and the lockdown that we've all endured recently. I think it's been something that's been on people's minds, the fact that they really should make a will, or hopefully, you know, people have been considering that kind of thing. But unfortunately, you know, because of the lockdown and the situation, I think there's likely going to have been wills made in situations where they may not be robust. There may be things that in the way that the will making process has taken place, that means that those wills might be open to challenge for other reasons, not under the Inheritance Act, but perhaps the validity of the will itself, if it's not been, it may not have been witnessed properly, you know, with social distancing, that you know, I've heard of wills being witnessed over video, or you know, over Zoom.
yeah, that's right. And actually, we're still on the Wills Act 1837, aren't we? With, you know, having to be physically present. I mean, I know I've had some bizarre experiences in lockdown, witnessing wills leaning on bonnets of cars and things like that, you know, but that physical presence is essential. And I think probably, Nicola, you know, if you are presented with a homemade will as a litigator, your starting point may be that there's going to be something there that you can have a go at, isn't there?
Absolutely. I mean, a homemade will is a litigator's dream in terms of trying to pull it to pieces for various reasons. Even with homemade wills, it's not often that you'll get anywhere in relation to the witnessing, the execution of the will itself. It's not a common area of challenge because, I mean, quite frankly, in normal circumstances, you would hope it's not difficult to get that bit right. Mm-hmm. But the first thing that any litigator is going to do going forward is, if a will's been made in 2020, that's going to be your first thought: is this a will that's been properly and validly executed? Before we even get on to the other topics that we would usually investigate in much more detail. So yeah, it's a real, I think it's going to be a hot topic going forward, potentially. But again, you know, if people have made wills in lockdown, there's no reason why that can't, if they've got any concerns, why they can't address those now. As you know, you can make a new will every day of the week if you choose to.
Absolutely, yeah, yeah.
And it's only the last one that really counts if it's done properly. So, you know, if anybody has made a will at home in the lockdown, then it's a good idea for them to be thinking about whether they're happy with that, whether they've got any concerns, and whether they want to readdress that and do a new one.
Yeah, absolutely. I mean, I think not everybody's comfortable, you know, meeting over Zoom or FaceTime or whatever, but, you know, the lockdown is now easing, and certainly at Napthans, we are open for business again, aren't we? Yeah. We're taking great care to keep both ourselves and our clients safe, but we are now able to meet with people and just make sure that those arrangements that they've put in place in a fully informed way, and with the benefits of advice from an experienced lawyer. So yeah.
Even outside of the lockdown, you know, people, I understand, you know, they think that there'll be a saving to themselves if they don't go and see a lawyer and they do it at home. But, you know, it can be sort of a spare a penny, spend a pound scenario, because down the line, you know, if the will's been done in a situation where it's not been subject to that lawyer's involvement and the processes that we put in place to make sure the will is robust, you know, it opens up the door for all kinds of arguments to be made about the will and the circumstances surrounding it. So yeah, by all means, it's advisable to get in to see their lawyer, get it done properly, and then hopefully their family won't be dealing with somebody like me.
That's right. Anyway, Nicola, I think our conversation is supposed to be brief. I know you and I aren't generally very good at that, but maybe we ought to wrap it up for today. I know, as always, it's great to talk about these things, Nicola, and hopefully, you know, anybody who is listening, you will take on board, you know, firstly, the importance of making a will, and secondly, making sure that you do seek the advice of a properly qualified and experienced professional when you are doing so. All right. Thank you very much. Bye.